And you may proceed.
Please, the court. My name is Craig Cunley, and I am representing the appellant, Louis Demas. And again, noting that this court actually reads the briefs, I'll just summarize. My client's argument on appeal is that Judge Forchione, in taking custody and control of a $5,000 fine, first of all, acted unlawfully. And I cite 4 or 5 appellate cases for the proposition, which is rather common sense, that fine money at the county level goes to the county treasurer. Judge Forchione deemed it appropriate for some reason to take the fine money and to send it to an out-of-state charity. Another client of mine sued him in a deck action. I think the day after service was made upon Judge Forchione of that declaratory judgment, he called, the record will reflect, the charity got the money back. Then the declaratory judgment action would have appeared to be moot, except that when the money came back, what was the clerk of courts to do with it, because there's still an order that said it goes to a charity in Connecticut. So Judge Forchione held a teleconference hearing, a resentencing hearing. In his resentencing order, which I believe was just about identical to the original one, he removed the language that the fine money would go to the charity in Connecticut, at which point my client voluntarily dismissed the deck action because there weren't any controversial, justiciable controversies alive at that time. Then Mr. Demas comes along and files a charging affidavit based upon those same set of facts. I enter an appearance in the municipal court. We have what amounted to just oral argument before the court. There was no evidence taken. It wasn't really a hearing. It was just oral argument of counsel as reflected in the court's judgment entry. And the visiting judge determined that there was no probable cause to find any criminal conduct. We have cited in the brief the applicable criminal code sections, the most important of which I think is 2913.02A1, which essentially says no person shall, with purpose to deprive the owner of property, knowingly exert control over that property without the consent of the owner. That is exactly what Judge Forchione did. And for some reason, the trial court judge threw in kind of dicta fashion, it was doubtful whether or not this $5,000 belonged to the county. I don't think that's doubtful, but let's say it is. One thing for sure, that $5,000 did not belong to Judge Forchione. And Judge Forchione had neither lawful authority nor consent to do anything with that money, which he personally received the check for, except to tender it to the Stark County Treasurer. Instead, he sends it to an out-of-state charity. I believe that meets the criminal elements of that code section. And I cited to the court the Adams case, where a low-level Bureau of Motor Vehicles clerk failed to collect the $5 late charge a few dozen times. She didn't actually get the money. She just didn't collect the money. She was indicted and convicted and affirmed by the Court of Appeals under the same statute involved in the Judge Forchione matter. And I guess I would say if a low-level Pee-wee clerk is held to compliance with the law and she didn't even get the money didn't actually exist, she just failed to collect it. And the appeals court I think appropriately found that in failing to collect that money, she deprived the rightful owner of that money, therefore it was a crime. Here, it's even more egregious in that the money actually existed. It actually went through Judge Forchione's personal hands. He gets the money. He doesn't give it to the county treasurer. Instead, he sends it to Connecticut Fund and ultimately has to return it.
The check is made out to Sandy Hook Elementary
Yes.
Fund. So it's never made out to a person, to Judge Forchione.
Oh, no, I didn't say that the money, he handled the
When
cash.
you're saying that personally given, it sounds like it was.
In other words, according to the record before this court, the check was tendered directly to Judge Forchione, presumably by the criminal defendant's attorney, because I think he was in prison at that time. And Judge Forchione took custody of that money and sent it to Connecticut.
How did that come into the record? I was curious.
I'm sorry.
How did that become part of the record? Because, again, not having a transcript or anything to this, how do we know that that's how that was done?
Because I had filed with the trial court a memorandum incorporating those documents, and the trial court indicated in its judgment entry that it had reviewed those filings I had made. So it is part of the record before the trial court.
Right, so you state in your memorandum certain things happened, and that's how it's proven to the court.
Not only stated, Your Honor, I actually attached copies of the correspondence. Judge Forchione memorialized what he did.
Okay.
And in his judgment entry, I think there were two judgment entries. One was the defendant's ordered to pay this money a run. And then after Judge Forchione got the money, he submitted signed and filed another judgment entry indicating a fait accompli, that he had actually done that. And he attached to that his correspondence to the fund saying, here's the check, and I thought it was more appropriate that it go to you, and then parenthetically, than to where it should have gone, the Stark County Treasury.
Mm-hmm.
So the case against Judge Forchione is predicated upon his own signed and journalized entries. It's no he said, she said, and I think as the trial court said, none of the facts are in dispute. Here's what happened.
Yeah. I'm sorry.
Can a court order restitution to an individual and not have it go through the Stark County Treasury?
Yes, but this wasn't restitution, Your Honor. This was a criminal fine. And in a criminal fine, Stark County Common Pleas Court judge has no lawful authority to do anything with that money except it ends up in the Stark County Treasury.
Or suspended?
Well, suspended, but of course that's not what happened.
Yeah.
This fine was levied. The judge used his official position to misdirect that money away from the Stark County Treasurer and into an out-of-state charity.
I'm sorry.
No, that's right. No, just a couple of points I'd like to make sure.
May I save a few minutes for rebuttal too?
Surely may. That's no problem. The trial court's standard of review of what the prosecutor did was an abuse of discretion. Is that correct?
Yes.
You agree? Okay. And then, of course, the appellate court's review, our review, standard review of the trial court would also be an abuse of discretion standard. Do you agree?
Yeah.
That's as I understand.
Yes, I believe the standard before this court is, did the trial court abuse its discretion in making the decision it made?
The judgment entry uses the phrases, affidavit was not filed in good faith and claim was not meritorious, which is two of the requirements, I think, under the of what the court could find based upon why they would not issue a probable cause or these charges. They seem to indicate here that his failure to appear and testify in support of his affidavit was significant. Now, how do you respond to that, the fact that the complainant does not appear and then, testify, here's what's happened, here's why I filed?
Well, I don't consider it to be significant or relevant for two reasons. Perhaps the best one is the trial judge didn't indicate in his judgment entry, and of course judges speak through their journalized entries. he doesn't make any mention of that or any assertion that that somehow was relevant to his decision, and instead he said he based it upon review of what had been filed with him and upon oral argument of counsel.
Well, am I reading this wrong? The last
Yeah.
sentence is, therefore, the court finds the affidavit in question was not filed in good faith.
Yes, of course.
It does not contain a meritorious claim.
Yeah, it says that, but that is not the same as, I believe, what Judge Wise was asking.
I added a condition to that.
Did the
was
court...
The failure to show up and testify to support the affidavit, yes. And that was correct, Mr. Conley. That was part of my question. I believe that obviously opposing counsel raises that issue. I guess my question to you is, even if the court hasn't spoke to it, is there a necessity or is there a requirement that a witness appear in court and substantiate the affidavit filed or not, or is that not a requirement?
Not of which I'm aware, and I don't believe opposing counsel had submitted any authority. And I dealt with that issue, Your Honor, in my reply brief filed with this court on August 30. I'll call it the charging affidavit statute, contains no such requirement. I couldn't find any case law, and I don't believe any was submitted by opposing counsel. And I liken it to the notion, and I know this court has dealt with it on many occasions, where you have a foreclosure case, and you have some accounting bureaucrat in Minnesota who looks at the records and submits an affidavit based upon personal knowledge that the defendant didn't pay the mortgage on time, and that these are true copies of the mortgage documents. This court has affirmed that methodology as being appropriate for someone with availability of business records to review documents, to sign an affidavit. Now, the person in Minnesota isn't in Stark County, doesn't really have the strictest sense personal knowledge, but the personal knowledge gleaned from a review of records. And that's what Mr. Demas did. He reviewed the publicly available records, that is, those two judgment entries, and based upon that knowledge, his affidavit says, here's what happened. His testimony would not have added anything. There was no need for his testimony. Still kind of a head scratcher to me why he didn't show up, but it wouldn't have made any difference. And I'm unaware of any statutory requirement or any case law. Plus, the trial judge said he made this decision based upon the filings made by me and upon oral argument.
Well, the reason I come to that concern me is when normally in a trial proceeding, an affidavit in and of itself to prove a fact isn't necessary. It may be allowed to allow evidence to be presented to the court through saying this is an authentic document, these are true and accurate documents. We're looking at a very strong standard of review here, the abuse of discretion standard. Prosecutors, as I read, don't have to always prosecute. There's a basis for doing so. So when it comes to trial court, the trial court says I have an affidavit which I can look at, and he has, I guess, a credibility issue. Somebody, do I agree this was filed meritoriously or not? And there's not a lot, and I understand your argument going through the documents, and it's well placed. But I have to look and say, why would the court, how has the court, quote, abused that discretion? If he says, look, I'm discrediting this affidavit, I'm not agreeing to something saying, so I don't think this was filed in good faith, without the testimony of the judge or without the complainant being forwarded testifying, here's what happened. How do I know that the court abused discretion in simply discounting that or not agreeing to that? That's a tough place for this court.
Because, Your Honor, this is a special statutory proceeding. This is not the classic case of a witness coming in and testifying at a preliminary hearing, yes, I saw Joe shoot Harry. This is based upon records that are of public records, publicly available records. And Mr. Demas reviews those and cites to those, and I maybe even attached them, I don't recall, to his affidavit. And as I indicate on page 2 of my reply brief, the underlying I'll call it the charging affidavit statutes 29, 3509, and 10, all that's required is a reviewing official, and I guess it can be a clerk or clerk of courts or a judge. All that's required is the review of the affidavit. You look at the affidavit, is it meritorious or is it not? There's no requirement that the court even hold a hearing on the affidavit. I think the court can throw it out sua sponte. So I don't think it's relevant that Mr. Demas did not show up, and apparently the trial court didn't consider it relevant because it didn't mention it.
Assuming, even though he doesn't show up, the court has the ability to say, I'm going to go with the affidavit or not. It's a piece of paper in front of me. It says certain things. I've got these things in front, and it comes to that abuse of discretion standard. And we all read those words. We know it's beyond an error of law, for crying out loud, but whatever that might mean is we all challenge sometimes. So I guess I'm just looking for something there when the court says, look, I don't think it was filed in good faith. That's a pretty broad standard. There's no findings of fact or anything required here to say why he found it wasn't in good faith. That wasn't necessarily challenged, other than it was appealed. I guess that's it. I'm trying to glean out where that comes from, along with the, as far as not meritorious, I think that's a more direct argument you presented. You've shown what was done factually. The court says I did these things. It's that not filed in good faith. I'm not sure where that goes to, but the court makes that finding. So,
well, the court had echoed the statutory language, and I would suggest that filed in good faith and meritorious are one and the same. If I make an argument to you that has no merit, particularly if I should know better, and as an attorney I guess I should, it would seem to me that argument's made in bad faith. I think those terms are, in this context, pretty much one and the same.
I would go well with you, but have you sat as a judge long enough, I've seen some not so meritorious claims filed in good faith, just because it was just possibly in my first 10 years I may have violated it. So, but with that in mind, and that's enough on the subject. But that's an area I had to figure out. Thank you.
Any other questions, Your Honors?
No, you have about 3 or 4 minutes left.
Thank you.
The state, I guess. The state, right, the city.
Your Honor, members of the court, I appreciate your time this morning. Thank you. My name is Craig Morgan. I am the Deputy Chief of the City of Akron Prosecutor's Office. I stand here before you today as a special prosecutor appointed to represent the City of Canton in this matter. The issue before the court today is very narrow. It is whether or not the trial court abused its discretion in finding that the affidavit was not filed in good faith and did not state a meritorious claim. By extension, the trial court denied to find probable cause to charge the named defendant with the offense alleged, which is theft in office, in this case a felony of the 4th degree. There are 3 reasons why the trial court did not err. 1, there was no abuse of discretion. As we've heard in earlier cases this morning, and as Judge Wise brought up, it is a high standard. It is not just mere error of law or judgment. It is a showing that the court abandoned its impartiality, that through will of perversity or through prejudice, that the court made its decision based on it was unreasonable or unconscionable or arbitrary. And, Your Honors, I suggest to the court, there are no facts. There are no facts in the record. There are no facts in the brief, and quite frankly, I don't think there are any facts in appellant's argument as to how the trial court lost its way so much as to say that it was unconscionable. In fact, if you look at this situation, due to the nature of the named defendant, a special prosecutor was brought in. Due to the nature of the named defendant, a retired visiting judge was brought in, just to avoid any appearance of bias or partiality. But when you look at abuse of discretion, we have to look at the burden. And as someone who has been a prosecutor for his entire 12-year law career, I am happy to tell you that for once I do not have the burden. It is the appellant's burden to show from the record, to cite from the record through the transcript, facts to show why the court erred. And there are none here. Additionally, Your Honors, on the issue of good faith, the reality is, though there is no statutory requirement that testimony be taken, part of that is that there is no, as we've mentioned here this morning, there's no requirement that hearing even be held. A judge, sua sponte, could choose not to pursue the affidavit. Or one of the other reviewing officers could just be the prosecutor. A prosecutor. The case of Evans out of Columbus, reviewed by the Ohio Supreme Court, just simply involved the city prosecutor refusing to pursue charges. And of course, in that case, the Supreme Court said, no, of course not. A prosecutor is not mandated by Revised Code 2935 and 09 and 010 to prosecute charges that they do not wish to do so. The standard of review for the trial court of the prosecutor's decision is abuse of discretion. The standard of review of the trial court's decision by this court is abuse of discretion. When we look at the non-appearance of the affiant, as I stand here today, I still do not know if he exists. And as pointed out, no prosecutor can walk in with an affidavit into a trial and present it. We need witnesses. There is no police officer that responded. There is no investigative agency or investigative detectives that handled this case. There is no prosecuting witness. There is no victim. There is no witnesses. There is no evidence. There's no physical evidence. There's no phone records. There's no bank records. There's nothing that a prosecutor could do to pursue this matter.
What would the complainant being present testify to? The affidavit's there, so, the person, the affiant. What is it that the affiant, if present, would be required to testify to or would testify to?
Well,
opposing counsel suggests it's not necessary. We have the affidavit, and that's significant. I'd like to know why you would need that.
I would like to start with the basis of his personal knowledge. It is his credibility. He is the witness to this case. He has chosen to file a charge, setting aside for 1 minute that the named defendant is a sitting judge. If an individual chooses to read a newspaper and then look through some pertinent public records and then demand a felony be signed against any person in this county, that concept is frightening to me, Your Honor. So his credibility is the primary focus. It was of such great importance to him after hearing about the outcome of this Studer case that he filed this affidavit, but it was yet of so little consequence that he could not be present to be heard at the hearing that was set on behalf of his affidavit. Now, as for the meritorious claim, I disagree with opposing counsel in that I do believe they are separate and distinct. For a claim to have merit from a prosecutor's perspective, it means we must have sufficient evidence to corroborate the claim. We must have sufficient evidence to prove each element of the offense beyond reasonable doubt. And what's lacking here is any evidence of the requisite culpable mental state knowingly. And there is a little bit of confusion in the parties' briefs about intent. I would not for one moment attempt to suggest to this court that intent is an element of the offense of theft in office. But what intent is, it is one of the most dominant and persuasive forms of evidence for proving the culpable mental state. Now, I know as people reflect on this matter, someone will certainly say the next time I get a speeding ticket, I'm going to tell the police officer I didn't intend to do it. However, as we all know, as with most of traffic offenses, speeding is a strict liability offense. There is no culpable mental state. But if we set aside prior calculation and design for a second, which is limited only to capital cases, we have 4 culpable mental states: negligent, reckless, knowingly, and purposely. Knowingly is the second highest standard that a prosecutor is forced to meet. It is not just someone being aware of their conduct, but being aware of the nature of their conduct. And that's really what we get here. We have a couple of journal entries submitted to suggest that a judge here tried to take a local tragedy. The case in question involving Mr. Studer involved an individual who was a high school coach who was recording his students in the locker room. And obviously he's now serving 15 years in prison. the judge attempted to take a local tragedy and aid a national tragedy, which was the Newtown, Connecticut shooting. And if anything was done here, it was a mistake. But how I could possibly, as a prosecutor, look at 2 journal entries and find the culpable mental state of knowingly, I can't imagine. And that's why I say not only was it not filed in good faith, but there is no merit to the claim. And with that being said, Your Honors, I would just ask you to reflect on the fact that the burden does lie here with the appellant today, due to the fact that there is no transcript of the proceedings, there is almost no record of the proceedings. I do believe it is appropriate, without any evidence to suggest any irregularity in the trial court's reasoning here, and especially considering the high standard of abuse of discretion, that you do find in favor of the appellee. Thank you.
Thank you very much for your services. Mr. Conley, you have about 2 or 3
just a
minutes. I'll
couple
give you during the
Points. Thank you, Your Honor. I know counsel did not answer Judge Wise's question about what would the affiant have added to the proceedings. I guess I've done that myself when I don't want to give an answer. I dance around it, but that's what happened there. This was not a trial. This was not a classic prelim. This is a special statutory proceeding. And although opposing counsel called the concept of this affidavit methodology to be frightening, maybe it is frightening. He should write to the General Assembly, because it is a statutory enactment in Ohio that allows this methodology. Is it a good idea or a bad idea? I don't know. That's not my role. I don't think it's this court's role. As far as this...
So let me get this clear. What the culpability is the wording is further ordered that the defendant shall pay a fine in the amount of $5,000, which the court orders to be forwarded to the victims of Newtown, Connecticut tragedy.
Yes, Your Honor.
It doesn't say given to me. I would imply that the clerk Reinbold would be the one to say.
Well, I don't know that in fact, I would affirmatively state the underlying criminal statute 2913.02A1 doesn't require the money or the services or the goods to go to the person accused of the crime. I can steal from you, Your Honor, and give it to Judge Baldwin. I didn't get the money, therefore I didn't commit a crime. The gist of the offense is to misdirect somebody else's property. And as far as the knowingly, that term is defined in 2901.22B, that's covered in my reply brief. And it indicates regardless of purpose. Did Judge Forchione have a doing God's work motive? I don't know. Was he just grandstanding? I don't know. But it doesn't matter. He took somebody else's property, and he is deemed to have known that in doing so, it deprived the rightful owner of that property.
How does Mr. Demas have to complain about the Stark County Treasurer's property when I note his address is Columbus, Ohio?
I don't know that the statute has that sort of standing requirement, Your Honor. I haven't researched it. You're the first time I've heard the question asked. I would think that any citizen of the state of Ohio would have standing, and I believe, and I'm not sure it's in the record, that Mr. Demas owns real property in Stark County, and I don't recall if that's in the record or in his,
I just looked at the document.
in his affidavit. And finally, Mr. Morgan made a lot of fuss about, from a prosecutor's perspective, he didn't have much confidence in being able to get a conviction. That isn't the role of the judge in this special statutory proceeding. His role is limited to, is there enough meat and potatoes, enough probable cause to bring criminal charges? It's not the judge's role to win the case. So even if the prosecutor might be inclined to think, I can't win this case, that's not the issue under this statute. And that's not the issue that was before the trial judge. And finally, as to the notion of arbitrary, I would say that in light of the evidence before the trial court, and noting, as indicated in my brief, the hearing started at 9 o'clock, the judge magically, a visiting judge no less, has typed, prepared, filed out of his county the judgment entry throwing the affidavit out in an hour and a half.
Well, but, you know, computers are wonderful things. Look at us up here.
Yeah,
I
well,
mean, Judge, if he wasn't true to himself, he could be typing the opinion on this right here. Just be sitting
yes, but
here.
he's studiously paying attention to my argument, Your Honor, so of course he wouldn't be doing that.
You've never seen me type either, so.
No, I mean, of course, it's possible it could be done in an hour and a half, but I would submit it is arbitrary based upon the evidence before the judge.
You are truly out of time now. Okay.
Yes, thank you.
Thank you for your patience in waiting around. I'm sorry we got a little delayed. This matter is hereby submitted. We're going to take a very short recess. Just a few moments, everybody at heart.